this is something that happened in Parliament this week, in the Sri Lankan Parliament. It's concerning a ruling of the Speaker on domestic debt restructuring. Right? So we all know that if Parliament is the place where bills are formulated and bills become acts, when a bill is tabled in Parliament, then the public have an opportunity to take the bill and they can go to the Supreme Court and ask the Supreme Court whether the provisions of the bill are consistent with the Constitution of Sri Lanka. If it is not consistent, the Supreme Court will suggest certain amendments for the bill, and then it will say whether it can be passed with those bills, and sometimes the Supreme Court might even say you need a 2/3 majority or a referendum to pass that bill. That's what the Supreme Court would normally say. Sri Lanka doesn't have a post-enactment judicial review system. That is, after a bill is passed in Parliament and the Speaker signs off, it becomes an act of Parliament, becomes the law. Sri Lanka doesn't have a system where the public are allowed to actually take that act to the Supreme Court and again debate it and contest it. So there is no post-enactment judicial review in Sri Lanka. Lots of democracies have it, but Sri Lanka doesn't have it. In fact, it's my view that Sri Lanka must have a post-enactment judicial review. And the reason that I stand for that view is when a bill is brought, it's presented in Parliament, it's debated, and we are voting on it. Before the final vote, at the committee stage, we pass amendments. When we pass the amendments, the nature of the bill can be changed. And sometimes there's a possibility that the amendments we pass may not be in line with the Constitution of Sri Lanka. And then we will pass it and it becomes law. And the public have absolutely no right at that point to contest it or question it. That is why I strongly feel that post-enactment judicial review should be there in the country, so that we are always making sure that we are within the rule of law and within the Constitution of Sri Lanka. Now, last week, in a very sudden move, a minister, right, Harin Fernando, he raised a privilege issue in Parliament. He asked the Speaker to give a ruling on the court hearing on the resolution on the implementation of the domestic debt optimization. Now, he has every right to bring any privilege issue. But the question here is, right, the actions of the Speaker. So the Speaker actually ruled, and I'm quoting from the ruling, he said, as a resolution for the implementation of the domestic debt optimization to restore sovereign debt sustainability was passed by Parliament on the 1st of July 2023, and the resolution is beyond the jurisdiction of the Supreme Court or any other court established under the 1978 Constitution of Sri Lanka and cannot be questioned and or reviewed and nor challenged. This is, I'm quoting from what the Speaker has said. He further went on to say, right, no court established under the Constitution of Sri Lanka is empowered to issue orders or judgments of any nature against a resolution already passed by Parliament, having followed the due parliamentary process. And any such order or judgment of courts would amount to violation of the items 1 of Part B of the Parliament Powers and Privileges Act, number 21 of 1953 as amended. Now I have a few questions. I have these questions for the Speaker of the Sri Lankan Parliament and also to the legal fraternity of this country. Right? And the questions are, is the motion on domestic debt optimization actually a law? Because you bring a bill, you table it, public are allowed to challenge it in the courts for its constitutionality, and then after that we pass it in Parliament or we pass it through a referendum, it becomes a law of the country, and after that there is no post-enactment judicial review. That's understood. Now this is a motion on domestic debt optimization that was brought to Parliament. It's actually an executive action that is being carried out with a vote in Parliament. Right? And therefore, my question is this actually a law? When a motion is brought right to Parliament and it's passed, is it a law so that it cannot be actually challenged in a court of law? Then my question is, if it was a law, then there should have been a bill, because the bill is presented and people are allowed then the stipulated time period to go and actually challenge it in a court of law. And then we would know about its constitutionality. Is this a regulation? It's another question. What actually is a motion in Parliament? We can have all kinds of motions in Parliament. Right? An MP can bring a motion and saying, let's close down all the courts in the country. In fact, a member of Parliament during that discussion in Parliament actually said it. Right? And then we take a vote and the motion is passed. If that motion is passed, saying that all the courts in the country should be closed, right? Just logically think about it. Does that mean that we can close all the courts? And therefore, this issue cannot be taken to a court of law and be contested in a court of law? I think we need to be clear about the powers of Parliament and the powers of the judiciary. Parliament is supreme, but we need to be clear on what we are supreme. We need to be clear about that. Parliament is supreme, but on what are we actually supreme? That's what we need to be clear about, right? So, it's important for the Speaker to actually make an explanation on this ruling. It's very important because this certainly raises a lot of questions, and also the Speaker mentioned during the discussion in Parliament that he had got legal advice, and I would like to ask the Speaker to please make public who his legal advisors were and to please name them also. Right? And we are saying this basically in the interest of the population of the country, and we are saying this in the interest of actually protecting our constitution, right? And the foundations on which our constitution has been written.